All right, good morning, everyone. My name is Daniel Reeves. I'm the former senior advisor on offshore matters to IRS's Offshore Compliance Initiative. I retired from the IRS in 2012, and since then I've been functioning as a private consultant on offshore compliance, tax evasion, and anti-money laundering programs. The last 6-7 years, we've seen a dramatic change in the use and promotion of offshore financial centers for tax evasion purposes. Beginning first with the UBS case in 2008, the combined efforts of IRS and the Department of Justice have led to numerous criminal prosecution cases, increased international cooperation, improved information sharing, and a heightened sense of public outrage at those who would use offshore financial centers for tax evasion reasons, and also against those who would assist them in that purpose. To date, the Department of Justice's activities have resulted in 81 individual taxpayers being charged with offshore tax evasion, all of which have either pled guilty, been convicted, or are awaiting trial. 38 bank employees and financial service providers have been charged, all but 2 of which have either pled guilty or are awaiting trial or have been declared fugitives. In addition, 5 major banks have settled cases with the Department of Justice either through deferred prosecution agreements, guilty pleas, and there are an additional 14 banks which are under criminal investigation according to public sources. Meanwhile, the IRS has continued its activities, its separate activities. It has issued multiple Doe Summonses to banks and other business entities in an effort to identify U.S. citizens who are maintaining offshore bank accounts. They have run an incredibly successful offshore voluntary disclosure program that is providing much information about the offshore world and also has brought in billions of dollars in additional revenues. They also run a robust whistleblower program, which is providing detailed, specific information about activities that would otherwise be unknown to the IRS. With me today to talk about those activities and to talk about those efforts are 3 senior officials from the United States Internal Revenue Service. First, Brian Sternagle. He is the National Program Manager for IRS's Offshore Compliance Initiative, the program that promotes compliance with U.S. tax and foreign information reporting laws through enforcement actions directed at identifying U.S. taxpayers in abusive offshore tax schemes and the banks, the promoters, other financial institutions, and third parties who facilitate and enable their offshore financial arrangements. Next to him is Carolyn Schenck. Carolyn is a senior counsel with IRS Office of Chief Counsel based in Los Angeles, California. She has litigated numerous cases on behalf of the IRS in U.S. tax court. She specializes in tax fraud, foreign accounts, and foreign reporting penalties, and also assists the U.S. Department of Justice in cases involving Doe Summonses, injunctions, summons enforcement, criminal tax, and abusive tax preparers and promoters. Next to her is Lindsay Stellwagen. Lindsay is a special counsel international with IRS in Washington, D.C. Lindsay specializes in international tax compliance and enforcement litigation support in areas such as offshore banking, offshore structures, foreign government employees, foreign information gathering, treaty analysis, informant cases, expatriates, foreign athletes, and entertainers, and estate work. So you can see that we have a very diverse panel that is involved in pretty much all aspects of offshore compliance work. Before I turn the podium over to them to make their presentations, I want to give you a couple of disclaimers that need to be given. First of all, Brian, Lindsay, and Carolyn are here with us today in an official capacity to talk about some of IRS's offshore compliance and enforcement programs and activities. They have not been authorized to engage in any kind of general debate or discussion about offshore financial centers themselves or about U.S. policies towards OFCs. Also, they cannot discuss or answer any questions related to a specific investigation, negotiation, or any other discussion that you may have heard or read about in the media. What they are going to do is they're going to update you on some of IRS's activities to bring back into compliance U.S. taxpayers who would use OFCs and the secrecy that they provide for tax evasion purposes. So with that, Brian, I'll turn the stage over to you.
Thank you, Dan. I also, before we get started, I would like to thank David for the opportunity for the IRS to speak this morning. It's been several years since we've actually presented at this conference, so thank you, David. I want to start out by saying that the IRS is still addressing offshore tax evasion, and it remains one of our highest priorities organizationally. U.S. persons are required to report their worldwide income. The IRS is going to continue to take steps to identify areas of offshore non-compliance. We're going to look to regardless of where the transaction takes place throughout the world, we're going to look to see and identify that non-compliance. So I want to take a few minutes this morning and talk about the program that I oversee at the Internal Revenue Service. It's called the Offshore Compliance Initiative. Now, Dan, in his introduction to me, kind of gave the spiel about what is Offshore Compliance Initiative and what is it that we do. In a nutshell, what we do is we research internal and external sites looking for abusive offshore transactions from the IRS's perspective. We then, once we've identified what we believe is an abusive offshore transaction, we then take a look at external sources that may provide us information about those schemes or transactions. Then finally, we want to develop strategic initiatives or enforcement actions that will help us identify the U.S. taxpayers that are participating. Now, that strategic enforcement action that we use primarily is the Doe Summons. The Doe Summons is a civil compliance tool that requires court approval, and it's used to identify unnamed taxpayers. Under Internal Revenue Code Section 7609, we have authority to issue summonses to identify these unknown taxpayers. We can do that if we can establish three things. First, we have to establish that the summons relates to a particular person or class of persons. Second, there has to be a reasonable basis to believe that such person or class of persons may have failed to comply with the internal revenue laws. And third, we have to show that the information sought cannot be obtained from any other source. Like I said, it's been a couple years since we've actually presented at this conference, so I wanted to also spend a little bit of time giving you a bit of background about the Offshore Compliance Initiative. The program itself began roughly 10 years ago in our Small Business and Self-Employed Division of Internal Revenue Service. It started out as a project related to offshore credit card transactions. Initially, there was a small staff. Basically, there was one investigator, Mr. Reeves here, and we had support of a couple counsel attorneys. Now, since the UBS summons has been issued, the project has developed into a program. I now currently have 16 specialists that do investigations related to Doe summonses. I think the increase in staff has been a direct result to some of the achievements that the program has had and some of the successes that the program has had. Now, Carolyn and Lindsay, I know that both of you support the Offshore Compliance Initiative, and counsel resources have been really limited, but I think there's been a corresponding increase in the amount of support that our counsel has given us. Lindsay, you know, comment on that?
Yes, that's true. Where we had just a small cadre of attorneys working on the offshore audits, this has now gone national. So we have attorneys all over the U.S. who will work directly with agents, providing legal assistance, attending interviews of taxpayers, and providing strategic support.
All right, thanks, Lindsay. Since the UBS summons, we've also been realigned to our international area of our large business and international division. This has helped us align our strategic focus and priorities with the rest of our international organization. So I also wanted to talk just a little bit about what it is my staff does. I mentioned that there's 16 investigators out there right now. And we spend a fair amount of our time gathering information from both internal and external sources of information. And what we're looking to do is identify areas of non-abuse that we can support the issuance of a Doe summons for. Now, once we've secured enough information, then we put together the declarations and the packages that'll go forward to the court, and we do that in cooperation with our counsel. Once the court has approved a John Doe summons, we then will receive the information from the summoned parties. That information is going to generate leads. Those leads then come to my staff. We go through the leads, and then we'll refer cases to our examination function. Now, my staff takes a look at those leads. They provide information and guidance to our examination field in terms of what information we have, how to use the information, and as the examinations are ongoing, we also provide some guidance related to how to develop that information in the particular cases. Additionally, we provide expertise to the IRS in general related to offshore transactions. So my staff may actually testify on behalf of the government, for example. We often will talk about records, the availability of records, and what types of records we think can be secured by the taxpayer. We also provide direct support to various offshore programs. So for example, the Department of Justice has a current initiative going on related to the Swiss banking, related to Swiss banks, and it's my staff that provides support from IRS related to that initiative. We also support other strategic initiatives like the Offshore Voluntary Disclosure Program and the Streamlined Filing Program. Now, my staff, as Lindsay mentioned with Counsel, is located throughout the United States, and we become national in essence also. That gives us the ability to take a look at what's going on throughout the country related to potential offshore transactions. So prior to the UBS summons, what was that we looked at and what our focus was on offshore credit cards. Since UBS, we've issued 7 additional John Doe summonses, all primarily related to private banking. From those summonses, we've obtained a significant amount of information. And when you couple that with what we've received from the Offshore Compliance Initiative and the Streamlined Filing Program, we've actually been able to secure quite a lot of intelligence related to what's going on currently in the offshore transaction world. And we're using this intelligence then to generate additional John Doe summonses. In the next 12 to 24 months, you'll see additional summonses related to parts of the world other than Switzerland, and we're going to go beyond the banks. So intermediaries, service providers, and facilitators may be potential targets of John Doe summonses. And Carolyn, a little bit later, is going to talk a little bit more in depth about what it is specifically we've done and where we might be going. Now, with our activities in the Offshore Voluntary Disclosure Program, coupled with what our Criminal Investigation Division is doing, what Department of Justice is doing, and then the fact that we're going to be receiving a significant amount of information in the very near future under the FATCA provisions, it's really becoming a bad bet to try to hide money offshore. Individual taxpayers are going to be best served if they come forward and voluntarily disclose previously omitted offshore accounts. It's going to be much more difficult to deal with a situation once we've identified a financial institution or we've identified the taxpayer specifically. Now, the IRS does have programs that allow taxpayers to come forward and disclose previously omitted offshore accounts. One of those programs, the Offshore Voluntary Disclosure Program, has resulted in more than 50,000 disclosures and in excess of $7 billion collected to date since the program actually started in 2009. Right now, there's 4 ways that an individual can come forward and actually correct previous omissions. The first is our Offshore Voluntary Disclosure Program. The program, current program, started in 2012 and was updated in 2014. The program allows a taxpayer to come forward and disclose their previous unreported accounts to the government. In exchange, the government will guarantee a set penalty structure related to those transactions. Right now, that penalty structure is 27.5% of the omitted accounts and/or assets that were offshore. That penalty will increase to 50% once we've identified the financial institution that helped facilitate that transaction. In addition, the taxpayer will have to correct 8 years of returns and pay the tax, interest, and an accuracy-related penalty associated with those 8 years of returns. This program does allow for protection from being referred criminally. So there is some criminal prosecution protection under this program. The second program is the Streamlined filing program, and this allows taxpayers whose failure to disclose was non-willful in nature. Under this program, the taxpayer would have to correct 3 years of returns and pay the appropriate tax and interest with those 3 years. There's separate paths for individuals that reside in the U.S. versus residing outside of the U.S. If an individual is residing within the United States, they pay the tax and the interest associated with those years, plus an offshore-related penalty, which serves in lieu of all other penalties, and it's calculated at 5% of the omitted foreign financial accounts. The other is for those individuals that reside outside of the U.S., and those individuals basically can come forward and correct their omissions by simply filing the tax return and paying the tax and interest associated with the 3 years. The last two programs relate to filing of delinquent FBARs and foreign information returns. Now, under the delinquent FBAR proceedings, an individual that does not need to use the Offshore Voluntary Disclosure Program, the Streamlined Filing Program, and isn't currently under exam or been contacted by the IRS can submit delinquent FBAR returns. They can do this by following the normal filing procedures and then attaching a statement to that submission. That statement has to indicate why it was that the failure to file was there, or why they were late. And as long as they've reported all the income related to those delinquent FBAR accounts, the IRS will not impose a penalty for the delinquency of the FBAR return. The second program relates to foreign information returns. It has similar criteria. Taxpayer submits the delinquent returns under the current processes that are in place. They'll attach a statement explaining why they believe they have reasonable cause and certify that the transaction was not used for tax evasion. All right, so that's kind of in a nutshell what's going on in the Offshore Compliance Initiative. All of these programs kind of stemmed from the activities that's taking place in the Offshore Compliance Initiative, particularly the Offshore Voluntary Disclosure Program. As these are going on, there's also been an era of international cooperation, and Dan kind of alluded to that earlier, and Lindsay's going to spend a little bit of time talking about some of the cooperation that's taking place.
Thank you, Brian. As you all know, there's been 3 major pressures that have increased international cooperation. There has been the unprecedented globalization of markets, businesses, financial systems. There was the meltdown that we had in 08 and 09, and there were some significant, at least for the U.S., whistleblower events. And the whistleblower events were a real game changer for us. It brought attention to the offshore problem. It made things more difficult for individual taxpayers because you can plan for jurisdictional secrecy and laws. You can't plan for a whistleblower. So from a U.S. perspective, Congress also recognized the value of this. They changed the laws. They released the cap. They changed some of the procedures. And they gave whistleblowers access to the U.S. tax court. And we're seeing those cases come in. So the other thing it did for us is it increased international cooperation, because where the databases, some of them are just individuals that come in, individual businesses. They may be U.S. specific, but some of them aren't. They're global. They're cross-border. And so when we receive the databases or information other countries receive similar information. And that causes us to sit down at the table with those countries and talk about the databases, what's in it, manipulation, database management. So we've seen a lot more cooperation just arising directly from the whistleblowers. The other thing that we've seen a lot on the civil side is the exchange of information. So we have over 60 tax treaties. They have exchange of information, or EOI provisions in them. They've been strengthened in recent years. We've also expanded our TIA, Tax Information Exchange Agreement network. And since we were last at the OffshoreAlert, we've added TIAs with Brazil, we've revised the Caymans, Colombia, Hong Kong, and Mauritius. So not too long ago, we had a lot of audits in the pipelines with Liechtenstein Stiftungs, and we had some pretty serious issues. Today, Liechtenstein is a solid treaty partner of ours, and these exchange of information agreements are starting to be taken very, very seriously with the different countries. And it wasn't too long ago that the agents I worked with were not interested in putting in treaty requests. It was too long. The information took 18, 24 months to get through. What they got was no good, or they were told to go pound sand, basically. But what's coming in now is very good information. It's very good information that the agents are energized with what they're seeing. In recent cases, I have actually withdrawn referrals to the Department of Justice for summonses because the treaty information was so solid that resolved the audit. So it's also a two-way street. We're receiving a lot of requests from other countries, and we're providing information. You've probably seen that we did a John Doe Summons, as Brian discussed the John Doe Summons for Norway. And we also, as we always have, with certain of the treaties, we will also serve summonses for the other country in the U.S. and enforce them in our U.S. district courts. And I've been involved with some of those. We take them very seriously, and we push them through in an expeditious manner. The other thing we're doing is we're sitting down at the table with a lot of the other countries to discuss common problems, cross-border schemes, promoters who are operating cross-border. And JITSIC, the Joint International Tax Shelter Information Center, is one of these organizations. I attend their meetings periodically, and it's fascinating to sit there, and they go around the table, and each of the countries discusses what they're looking at, or what kind of situations they're facing, how are they resolving it, and there's a robust discussion about the issues. For those of you who may not be familiar with JITSIC, it started in 2004 with the UK, the US, Australia, and Canada. Germany and France joined as well. Korea, Japan, China were observers. They then joined. And in 2014, the membership was expanded to include all the members of the OECD's Forum on Tax Administration who wanted to participate. So now we have a membership of over 20. And the new JITSIC is a platform for participants to more effectively understand global tax risks and issues, and to improve EOI, increase cross-border collaboration, and conduct coordinated projects and initiatives. The other thing that I'm sure that you all know is coming up is FATCA, the Foreign Account Tax Compliance Act. And this focuses on U.S. taxpayers that have foreign accounts, and it focuses on reporting, and there's requirements for individuals reporting, there's requirements for withholding and reporting for foreign financial institutions, and for those countries where we have information sharing in place, there can also be the intergovernmental agency agreements. So under these, the foreign financial institutions report to their tax authorities, they roll it up to the IRS. For example, in November 2013, the Cayman Islands signed an agreement with the U.S., and under the agreement, the foreign financial institutions for the Caymans will report the tax information about U.S. account holders directly to their tax authorities, and that will be rolled up to the U.S. Whereas Costa Rica in that same month signed a reciprocal agreement, and so they will also roll up the information to the IRS, and we will do the same for them. So we will be getting in the next few years information on these, how this will affect our pipeline. We expect to see a lot of audits arise as we start to bump this information against the different databases that we have. The informational sharing also occurs on the criminal side of the house. And so our criminal investigations, which we call CI, is the law enforcement arm of the IRS, and they work with other agencies to identify trends and leads. For example, this year, CI and UK's HMRC hosted a 3-day event in DC, the inaugural Criminal Tax Symposium. And it focused on international crimes, cross-border tax evasion, and they had delegates from New Zealand, Australia, the Netherlands, Canada, and Norway. They also, CI assigns agents to key foreign embassies and consulates around the world, and this year they added a new post for Europol, and this will allow them to leverage partnership with those 40 countries that participate. Brian mentioned our OBDI program, which offers individuals a method or a path to come into compliance, and they also have to cooperate. So from the information that we get, we have a database, and we do data mine that database as to how taxpayers come into the system, how did they come into going offshore, where did they go, who are the facilitators, the attorneys, the accountants, and so forth. So CI is very active in mining data from there, and that leads them, gives them leads for money laundering, tax investigations, and so forth. CI also continues to use our treaty network of MLATs, Mutual Legal Assistance Treaties, to obtain information in support of their investigations. They also participate in Interpol, Terrorist Financing Working Group, the Finance Action Task Force, and so forth. And they work on a number of offshore initiatives that dovetail with the civil side of the house, including the whistleblower databases and the Swiss project that Carolyn's going to be talking about. So if we look briefly year to date, our fiscal year starting in October, we see CI has been involved with the deferred prosecution agreement of Bank Leumi in December of 2014, the first non-pros agreement with BSISA, one of the 10 largest Swiss banks, sentencing for unlicensed money transmitting businesses, Bitcoin violations in the Silk Road, promoters of tax fraud schemes, narcotics trafficking, money laundering, wire fraud, kickback schemes. So they've had a busy 9 months or so. And every year, the IRS has our Dirty Dozen list, and for 2015, hiding money and assets in unreported offshore accounts continues to be on the list. And so as we go forward, we've got a lot of exciting new projects, and Carolyn's going to discuss a little bit about where we've been and where we're going.
Thanks, Lindsay. You know, the IRS at events like this is always kind of like the proverbial cockroach on a wedding cake. So we appreciate the opportunity to speak with you this morning. You know, I'm going to take a couple minutes and tell you kind of where we've gone and where we're going. I want to focus a little bit on where we've gone because it's, again, instructive of where we're going to go in the future. Now, in recent years, the IRS has launched its offshore program by use of the Private Banking Initiative. In connection with that, we've done a number of very noisy initiatives and very noisy Doe Summonses that many of you are aware of. You know, our initiative there focuses on the use of offshore accounts in private banks by U.S. persons to avoid the payment of tax. Now, in connection with that initiative, we have done 3 Doe Summonses: UBS, HSBC NRI Services, and the Stanford Group of Companies. Now, as a result of those 3 John Does, we have received a tremendous amount of data, literally hundreds of thousands of leads on thousands of U.S. persons, all of which is being investigated by Brian's team. Now, the records that we've received in connection with the private banking initiatives have been extremely complete. account statements, wire data, deposited items, canceled checks, private banker notes, correspondence from the account holders to the institution, directing certain funds to be wired or certain things to happen in connection with the accounts. The other focus of the private banking initiative has been on correspondent accounts. Now, the Permanent Subcommittee of Investigations has long recognized the danger that correspondent accounts pose to the U.S. banking system. Basically, correspondent accounts could lead to unregulated and undisclosed in a clandestine way for persons, really to provide a gateway into the U.S. banking system. Now, to date, we have done 4 John Doe Summons packages on offshore banks related to their U.S. correspondent accounts here in the U.S. Now, those banks have been Wegland, First Caribbean, Zurcher Cantonal Bank, and Butterfield. Now, we have issued about 10 or 12 John Doe summonses in connection with those banks to basically every U.S. institution, J.P. Morgan, Wells Fargo, Bank of America, HSBC, Citibank, Bank of New York Mellon, just to name a few. And the records that we're receiving from them have also been complete. We have a tremendous amount of data from all of the correspondent accounts at this point, which we've received in connection with all of the John Does. And we literally have millions of transactions that we are looking at right now. Millions of wire transactions, canceled checks, deposited items. And what I want to stress here is that the information that we have is not just limited to U.S. persons, but it's any transaction that goes through the U.S. correspondent account. Now, the agents, Brian's team is combing through this data as well. We are coming across other data associated with noncompliance in other countries, and through our treaty exchange program, we are in the process of exchanging some of that information. Now, also, as Lindsay mentioned, in connection with the offshore program, we have been asked by our treaty partners, specifically Norway, to file John Doe summonses on their behalf. Norway had a program where it was looking at prepayment cards, which Norway identified to be a way for its citizens to avoid the payment of tax and to really kind of repatriate the money. So our team filed, with the Department of Justice's help, 18 John Doe summonses on a number of U.S. banks asking for specific cards related to this noncompliance problem. Now, we've also focused on the use of offshore merchant accounts as a way for U.S. merchants to avoid reporting gross receipts. We've looked at the abusive practices of U.S. brokers in connection with our broker initiative. And the service is also looking at abusive offshore service providers and trust providers. And I just want to take a couple minutes and talk to you about 2 projects that we've done, because again, it's indicative of what we're doing in the future. Now, the service, along with our friends from Australia and the UK, received a substantial amount of data regarding the true identities and the beneficial owners of thousands and thousands of entities and trusts located worldwide. In connection with that project, we have matched up the identity of the entity holder with thousands of U.S. persons, and those cases are now being worked by agents, both criminally and civilly, throughout the United States. Now, the second thing that we've done in connection with this initiative is probably the most exciting, I'd say, John Doe to date. It was filed last December in the Southern District of New York. It was basically, it was a John Doe relating to an offshore services provider located in Panama named Sovereign Management and Legal. Now, that information that we got in order for us to file the John Doe, we got from DEA. DEA had an investigation open as to online pharmaceuticals called Operation Adam Flowers. It led into a more specific investigation called Operation Atom Bomb, where, again, DEA was looking at the kind of the transfer of money and the transfer of drugs through this online system. Basically, DEA came across a tremendous amount of information indicating that there was abusive tax activity going on, and gave the information to us. So we spent about a year or so building the case, with Brian's agents, and ultimately filed the John Doe. Now, it's unique in that it's the first time we've gone that route, and we actually filed 8 John Doe summonses to 3 types of entities. We were looking at shipping entities, wire transfer type data, and then correspondent accounts. We were looking at the shipping entities, for example, FedEx, UPS, and DHL, is because we wanted the identity of the U.S. persons that Sovereign Management and Legal was sending the ownership type paperwork and other correspondence to in the U.S. Because the whole goal of a John Doe summons is to identify the U.S. person, because at the time, hence the John Doe, we don't know who the U.S. person is. So the second grouping of summonses related to wire transfers. And it was the first time that we've issued a John Doe to the Federal Reserve Bank and also to the clearinghouse, which operates an interbank electronic transfer system known as CHIPS. We also issued a John Doe to Western Union, which is not the first time we've done it to Western Union, but it's the first time we've done it in this project. We also had evidence that Sovereign Management and Legal was directing payments in connection with services provided to U.S. persons to HSBC USA by way of HSBC Hong Kong and HSBC Panama, because it was Hong Kong and Panama where Sovereign Management and Legal was transacting business. We have received information back from all of the summons parties at this point, and I suspect that we will be rolling out some cases in the next probably 6 to 8 months in connection with that data. Now, with all of these initiatives, the goal here is to essentially drive people into compliance. I think we've realized with websites like ICIJ that tax evasion is not just a U.S. problem, but it's more of a global problem. I think countries, including ours and the IRS, we realize that we're not going to audit our way out of this problem. So what we hope to do with these initiatives is to essentially drive people into compliance, either through the voluntary disclosure program that Brian discussed, or by just voluntarily complying and actually disclosing it on a regular tax return, filed with our agency. So I want to take a few minutes now to talk to you kind of where we're going and how we're going to get there. I'm going to talk about these a little bit in reverse order about how we're going to get there. So as Lindsay mentioned, as a result of FATCA and international cooperation, the financial world is getting much smaller, and the IRS's footprint is getting much bigger. We literally have millions and millions of pieces of data that we are analyzing and mining and quantifying. Now, this data has come from a variety of sources: voluntary disclosure submissions, John Doe productions, whistleblower data, websites like ICIJ, spontaneous exchanges from treaty partners. We are taking all of that information and looking at it. And it's really that intersection of data that's providing us with the opportunity to move forward, sometimes down a path that we've already been, but also going into a couple of new paths. Now, I want to tell you a little bit about kind of where we're going. Using this data, the IRS is going to continue with the private banking initiative. In the very near future, you will see a number of John Doe summonses, again, relating to correspondent accounts here in the U.S. of multiple offshore banks. Our offshore program has not always been just targeted at Switzerland. We are looking beyond Switzerland and worldwide to look at some of the other areas of the country or other areas of the world, where we see abusive entities and abusive individuals that are facilitating tax evasion. We have also identified a number of abusive offshore services providers, and we'll be issuing John Doe summonses with respect to them. Now, we're going to be getting into the area, not necessarily of the offshore service provider, like Sovereign Management and Legal, but we have identified a couple of other individuals and entities that are operating here on U.S. soil within the United States to help facilitate tax evasion on behalf of U.S. persons. We have found that these consultants are setting up structures, acting as nominees, providing mail forwarding services, all types of things, with the goal of helping U.S. persons hide their assets. We expect to get additional information from other law enforcement agencies, much like we did with DEA. The movement of assets through hidden accounts where the true beneficial owner is buried creates a financial vulnerability that's not just unique to the tax system. FBI is concerned with financial vulnerabilities relating to money laundering and terrorism. DEA, it's with drugs. IRS, it's with tax. So those types of activities where the true beneficial owner is hidden poses a problem not only for us, but also for the entire criminal justice system as well. And finally, we remain concerned with the way that funds are repatriated by U.S. persons back to the United States. You know, Brian alluded to the offshore credit card project, which was launched in 2000. That program started with 1 or 2 John Doe summonses to Visa and MasterCard, and then spawned, hundreds of John Doe summonses after that. The information that we got back from the offshore credit card project was just spectacular, for lack of better terms. We received information of about 7,000 cases that went out to audit. We identified about 40,000 U.S. persons that were using offshore credit cards. That information was used in 600 criminal prosecutions when we raised about $400 million in tax. So the offshore credit card project was spectacularly successful. We are and remain interested in the use of offshore credit cards, so I expect that we will be looking to that area again. So at this point, I think that wraps up our formal presentation. I'm going to turn it back to Dan. I think we may open it for questions at this point.
Okay, before we do that, we're going to open the floor up to questions. I'm sure there are some out there who would like to ask a question of the panel. But before we do, there's a couple questions I want to ask. You know, the whole concept of offshore historically has always been that you could go somewhere and put your money offshore. You could hide it in a bank where IRS, assuming you're doing it for tax evasion reasons, IRS could never get access to those records. It was just simply impossible. So, Carolyn, with respect to the investigative techniques and IRS's ability to actually get taxpayer records, how does a taxpayer get around this? And what about claiming the Fifth Amendment? Isn't that an absolute defense to just claim the Fifth Amendment and never have to turn over records?
No. The taxpayer does obviously have a Fifth Amendment right, which prohibits the right, it's the right of self-incrimination and to protect against that. But when you really kind of look down at the Fifth Amendment right, it covers 2 different spheres. It covers testimony and it covers the production of documents. For the most part, and the IRS agrees that if there is a situation where a taxpayer has hidden assets and is now under investigation, they most likely have a Fifth Amendment right and do not have to testify. However, with respect to the production of documents, that's a whole different ball of wax. In the last 3 or 4 years, there have been a number of cases that have worked their way through the circuit courts, and I think as of now, we're 100% batting on this one. But the required records doctrine essentially allows the IRS to get around the Fifth Amendment defense raised by a taxpayer. What that basically means is that there are certain records that are required to be maintained by a person who participates in an activity. So what that means is in the offshore world, a taxpayer is required to keep records under the FBAR regulations for a certain amount of time with respect to their foreign accounts. And so because of that, a number of different circuit courts have held that a taxpayer does not have a Fifth Amendment right because they're claiming the right over the very record that they're supposed to be required to maintain.
And how does IRS get it? I mean, you issue a summons to the taxpayer directly and then the taxpayer has to produce it?
That's right. And we've noticed, too, around the country that district courts are no longer buying the explanation from the U.S. person that I can't get the records or the records don't exist. We've been spectacularly successful in challenging that kind of a defense, which is essentially the defense of impossibility, meaning I can't get the records. District court cases all over the country have come down in support of the IRS and have ordered the taxpayers to produce the records. There's a case pending right now in Puerto Rico where a U.S. person is being fined $3,500 a week until he produces records based on his Stiftungs and offshore accounts. So it's something that the IRS has, told agents around the country that you've got strong legal grounds to go forward and to challenge the taxpayers' defense of either the Fifth Amendment or this impossibility defense.
And Lindsay, you mentioned that there's much more cooperation going on between various countries around the world. You referred to Liechtenstein especially as one that once was regarded as a secrecy jurisdiction, but now, has a robust treaty with the U.S. rather. As far as getting records from offshore financial centers, I know it used to be a time when you had a lot of difficulty getting records out. There were tax information exchange agreements, but sometimes they really didn't produce the kind of information you needed. There was limiting factors as to what they would give you pursuant to that. Are those things improving? Is there better cooperation going on with OFCs, and is there more information available through them?
Yes, absolutely, absolutely. And I'm not saying in every request we get everything we want, but we've gotten some startling, for us, responses. And the nice thing is with the agents is now the agents are see the value of it, and so they're putting in more requests. They're monitoring their requests. They're developing tight relationships with their tax attachés. They feel comfortable going to them, asking them for directly for information that they can get from public records, to interview people. We've brought people into the embassies, and the information that we've gotten directly from the countries has been of a high quality, which is spectacular for it. I mean, one of the reasons you don't see a lot of tax litigation in the offshore arena is because once we get the records, the game's over, and the taxpayers generally resolve it at that level. So we don't see the kind of volume you might see in the domestic arena where we have more of a tax issue. This is a records game, and we either get the records or we don't. The other thing that I think is expanding, in addition to the international cooperation that Carolyn mentioned, the law enforcement agencies, and the other parts of the IRS's international work outside of offshore, we do a lot of coordination within the U.S. government. And sometimes some of the agencies see themselves as an island, but even there, less and less, they see that, and they're seeing more and more interagency, interdepartmental cooperation, and that's starting to fall into the offshore arena as well. So that we have our friends at state, we have our friends at immigration, we have our friends at DEA and FBI, and we're seeing a lot more interest on their part of working with us and with us working with them.
I just want to add, too, that the other value of the data that we're getting from our treaty partners is that the evidence is coming to us, for those attorneys in the audience, in an admissible format, meaning it's coming with the proper certification of business records, so then we can enter it into a case if it does end up going to trial. Because like Lindsay said, I mean, this is a records game, and the taxpayer has virtually no defense to producing the records.
So when I first started in this game, the game was getting the records, and it was almost impossible to do that. That's changed. Those records are now coming forward, and it's getting easier and easier, and probably is going to become pretty transparent soon, right?
I think so, and I think you're seeing a lot of the district courts starting to come on board. They're seeing more of these kinds of cases. They're starting to lose patience with some of the arguments that the taxpayers are setting forth as to whether or not they can get a hold of the records. So I think that's true. I think the other thing that we're seeing more and more use of is the formal document request by taxpayers, where those documents, if they don't provide them and we follow the steps that are set forth in the statute, they will be precluded from bringing into litigation subsequently. So I think the IRS has a very strong handle on the document flow, and it's paying off in moving these audits fairly expeditiously.
I want to ask one more question, then we're going to turn it over to the audience for questions. And in many ways, Brian, you already addressed this, but I think it bears repeating. You know, some have suggested that the DOJ's resolution of the Credit Suisse case, which, while it included a very large fine, did not require the turning over of names, as was done with UBS, and the recent acquittals of former Mizrahi Bank executive Shokrala Baravayan and UBS executive Raul Wheel may have represented a turning point in IRS's enforcement activities. I know you can't specifically talk about those cases directly, but what can you tell us about IRS plans going forward? Is this a bump in the road, or is it mean nothing, or is it important?
All right, Dan, thanks. Yeah, I can talk a little bit about this without, again, touching on the specific cases. But I can tell you that it's not deterred what my program is doing at IRS. We're still moving ahead. Addressing offshore noncompliance is still going to be an extremely high priority within the Internal Revenue Service based on what's going on. It's, in terms of Department of Justice with the Swiss bank program, I think it's going to continue to be a high priority. The impact that those cases specifically have had, again, is probably going to be minimal in terms of how we're going to proceed going down the road and into the future.
Okay. All right, what we're going to do now is open the floor up to questions. I'm going to tell you what you probably don't know, which is that there are glaring lights in our eyes, and we can't see anybody beyond the first row. So I'm going to go back up here, and I'm going to ask if there are people who have a question, if you would raise your hand. And David, I know you're here somewhere. I assume maybe you have some people with microphones that can run to them. And when you ask your question, please ask it into the microphone so that everybody can hear it. Otherwise, I have to repeat it, and then that'll take away time from questioning.
I'll start off with a quick question. How can the IRS be certain that the information it requests is the information it gets, and does the IRS ever suspect that information has been withheld?
Absolutely. Absolutely. No, we look at the information. We've had public cases where we know that the information has been perhaps directed by the taxpayer. We have information that accounts have been closed that haven't been closed. We have experience with that. So it's more that when you get the positive information that we see, that's what we're saying that this is valuable. It's not because we're getting a lot of information that we question.
We have seen that too. There's a criminal case out of Hawaii that involved a U.S. person that was accepting money for the sale of certain types of missile systems, and he was taking those funds and wiring through multiple Swiss bank accounts into multiple entities in Liechtenstein. And we found that the defendant in that case provided a number of affidavits from one of the offshore services providers that was just 100% contrary to the information that our criminal agents working with FBI actually received pursuant to a mutual legal assistance treaty, where the declaration from the offshore services provider 100% conflicted with the Form A, which is, the KYC document that under Swiss laws is filled out regarding the beneficial ownership. So we have seen instances where false documents have been presented to us. And like Lindsay is saying, the world's becoming a lot smaller, so now we know what's out there, and we know the breadth of records that a taxpayer or U.S. person should be able to provide. The other thing, too, is that with the kind of expansion of the whistleblower program and the amount of data and the amount of people that have come forward to us, we've learned an incredible amount of information as to how offshore services providers operate and how foreign banks operate. And we've been told specifically the types of data that we can receive or should expect to receive with respect to certain types of accounts. There's a case in the Southern District of New York where the IRS was very successful in ordering the taxpayer to produce certain records. In that case, there was as part of the summons, there was a 2-page listing of all of the documents that we know that can be provided from a particular offshore services provider. So the bottom line is we know what's out there, and we know what we should be able to get.
Yeah, we also cross-reference data streams that come in. So, for example, with the Doe Summonses, we'll see what's available from one correspondent bank, and we might look at what did a different correspondent bank produce. And if there's discrepancies, we'll talk about it with the organization that's producing the record. So we generally have a pretty good feel for whether we're actually getting entire record set or not. And we have seen that.
We've also set up project declarants in some of these cases. We first did that in the offshore credit card, where we have an agent who has seen a lot of one set of project records, so they can point to the court. They can say, these are the kinds of things that should be present, these are the kinds of things that should be available, these are the kinds of documents that are reliable. I've seen hundreds of cases, I've seen thousands of cases, and they prove this way. So in addition to the individual declarant agent, we have a project declarant who addresses that. And that's been very successful for us.
At the conclusion of a case, like let's say a criminal case, or it's settled, will there be a paper trail? Will this be amenable to Freedom of Information Act requests, specifically to obtain information on the offshore services providers, the law firms, the accountants, the things of that nature?
Generally, the Freedom of Information Act is governed by Code Section 6103, which essentially deals with the disclosure of taxpayer information. So there's kind of a balance there between a FOIA request and 6103. And I know none of us on the panel here are experts in FOIA, but what we do know is that generally specific taxpayer information such as that is probably not going to be released. If anything, it'll be redacted. Just because we've got our marching orders from Congress, which is to basically protect taxpayer information.
That's right, unless you're seeking your own information.
Right.
Then that's different. But if you're seeking that of another person, as I said earlier, if we get the records, it's generally resolved at the exam level, so you will not see those records. It's when it goes to court that everything's public and you'll be able to see it.
Yeah, it's the public actions, the court proceedings, the Doe Summonses, that information is going to be available, but outside of that, generally it's going to be restricted because of the individual taxpayer.
If you were to look at the credit card project from what's public in the courts, you would think it was probably not terribly successful, because even though we were successful in the cases, there weren't very many of them. But if you were to look at the whole breadth of the exam results, that's where it's startling.
The other thing I just want to say, the credit card project, what it really did was it was the beginning of the IRS truly acquiring knowledge about how the offshore world worked, about what kinds of records were out there, about who the promoters were. It was, even though it was an incredibly successful program, and the biggest thing it did was it created that corpus of knowledge about the industry that allowed IRS to move on and develop all of these other kinds of projects and all of these other kinds of enforcement actions that have since resulted. It was a game changer.
Yeah.
Next question. Over here.
I'll just shout. My name's
It's okay, people are usually yelling at us anyway.
Thanks. My name's Ed Davis. I'm from here in Miami, and I'm Steve Rodney Davis. Thanks for coming. I have a question about facilitators. I think we all know that one of the biggest pools of facilitators are lawyers. And we know there are lawyers that we permissibly refer to this as estate planning. In fact, in Miami recently, there was a conference literally entitled How Do You Hide Your Assets? Offshore. And so obviously sometimes people say that there are reasons to hide assets other than tax evasion, but I've yet to see it. So if lawyers are facilitating, have you tested that by going after the records at the lawyers' offices here in the United States that would use the crime fraud exception as a basis to overcome the attorney-client privilege? I'd be interested to know if you've had success with that and if you've developed a body of case law on that.
You want me to take that one? Yeah. Of course, the crime fraud exception is always available to go outside of the attorney-client privilege or the attorney-work product privilege. We have issued a number of summonses to law firms asking for records that they know are being held by the lawyer, because what we've seen in a lot of offshore cases, whether it be the law firm preparing the voluntary disclosure submission or just reviewing the offshore records, the law firm is trying to mask those and hold on to those records rather than disclosing them to the government. So we have used summonses in that regard to get any records in the attorney's possession that are not privileged. We've also gone after contact information for attorneys, contact information for U.S. persons that are under investigation that are in the attorney's files, as well as looking at billing and retainers, because we found in certain circumstances that transfers from the very offshore accounts that we're looking at that the taxpayer is claiming is not his are being used to pay the lawyer's fees. So that's where we have gone in and really pushed for the records that are in the files. In terms of pushing for other documents, such as maybe legal opinions and that sort of thing, there is a body of case law out there. It isn't necessarily limited to offshore, but it's really along the concept, along the lines of reasonable cause. We know that reasonable cause is a defense to a number of different penalties, the FBAR penalty, negligence, that sort of thing. When a taxpayer goes to claim that in court, or even before the case gets to court, and they claim reasonable cause, one of the things they have to show is that they relied on an advisor and that they disclosed all the pertinent facts. Well, in a way, that's essentially a waiver of the attorney-client privilege, because the taxpayer or the U.S. person is essentially pointing the finger at their advisor. So that's kind of a way that we can go around the privilege as well. In terms of whether or not we've built up a specific body of case law with respect to the crime fraud exception with the offshore, I'm not aware of any cases that have come down the pipeline recently that have been specifically along those lines.
Can I just follow up on one thing? We've seen recently lawyers paying their payments for their clients to these offshore providers, so that we break the chain and we put a subpoena on the taxpayer's bank account. They're not going to see any payment. You're not going to see a payment to Sovereign, for example.
Right.
But they use the lawyer to, they pay their retainer to the lawyer, and the lawyer then makes the payment onward to the offshore provider. Have you been able to penetrate that at all?
We have, and we respect the attorney-client communication and the functions of lawyers, because there are a lot of law firms and a lot of lawyers and a lot of advisors out there that are providing competent legal advice to their clients. And so when we have a situation like that, we're looking at essentially summonsing the financial information from a client trust account located at a bank. And so that gets a little tricky, because the summons has to be pretty narrow, just so it covers that particular payment. And of course, the government has to even figure out that that payment is being made. So it is kind of a multi-step process. But if we do get to the point to realize that that payment is being made, then more often than not, and what I hope, and at least what I know that we would counsel our offshore program would be to do a narrow summons, so we don't kind of encroach some of those issues.
That's true, and a lot of times too, we'll just, if it's an individual that we're going after, it's much easier just to summons the taxpayer directly than the attorney, although certainly summons attorneys for the payments to follow that train and then follow it back up.
I think I just want to add one thing to it also, which is that I'm not a lawyer, so I can't speak to the legal issues. But in that list I gave you in the opening about the number of people that have been prosecuted and the number of banks and such, I said that there were 38 financial service providers and bank employees who had been charged by DOJ. About 3 or 4 of those are U.S. lawyers here in the United States who were not just providing legal advice about offshore, but were part of the scheme themselves. So, to the extent to which you are able to get access to those records is a legal question for lawyers to debate. But certainly, history has shown that you're exactly right, that many of the people that are actually facilitating and enabling this activity are sitting right here in the United States. Any other questions?
Can you talk about how information is actually delivered? Presumably it's not emailed as an attachment. How is it delivered to you? And presumably we're talking about substantial records. How is it delivered?
Are you talking about a John Doe or an individual audit?
When you make requests for information to other countries, how do they get that information to you?
It's delivered to us in paper form for the most part from other countries. Sometimes we've received, it on a CD or some kind of a data drive, but we generally don't receive information like that via email. The same thing also in individual audits, kind of a case-by-case basis, but for the most part we get a paper production. And the John Does, with the millions of wire transfers and that type of data that we've gotten, we've asked for an electronic production of it, just because we're not in a position to handle 10 100,000 or 2 million checks, which we've seen in one circumstance, so.
So when
We-
the Swiss turned over substantial records, that would have been electronic, right? You're not talking about paper.
I'm sorry, the tail end of your question cut out.
When the Swiss turned over records relating to however many thousands of accounts, those records would have been electronic, right? Not paper.
They were individual discs.
Yeah.
So we had an individual disc for each specific taxpayer that the information was turned over on.
And those disks were searchable, right?
Yes.
Yes.
Wait for the microphone, please.
Have you found that your MLAT requests have reduced substantially due to the exchange of information? Is the criminal side able to get enough documentation from exchanges from other countries as opposed to having to go the MLAT route, which I imagine is still very cumbersome?
I think the answer to that is they're still able to get a tremendous amount of information. A lot of times, the criminal division does have a couple of different options, whether it be the treaty or the MLAT, so it's a little bit easier for the criminal division to get records, just because a lot of our treaty provisions don't provide for the same definition of civil tax fraud as they do with criminal tax fraud. But I know that the MLAT process does take a while, but we have noticed that it's been speeding up just because other countries are starting to make similar requests to us, which they always have, but the requests are becoming much more common as this problem is being identified as being much more of a global problem.
And I think the safest answer is to say they're going to do whatever they can get the records with the quickest.
Right.
They have access to the civil records that you're getting on the exchange.
That's right.
Yeah.
The
We
difficulty- yeah.
coordinate with records we receive. We, share information, so to speak, with the criminal side.
The difficulty is sharing the other way.
Yeah.
Because there's certain limitations with respect to documents received pursuant to a mutual legal assistance treaty that, depending on the country it comes from, the civil side might not be able to use the records. And of course, the criminal process too could obtain records in connection with a grand jury subpoena, which may have some impact on whether or not it can be used civilly.
Has Switzerland ever made a request for information to the United States under the Tax Information Exchange Agreement?
I don't think we can answer that question. Yeah.
Yeah.
In Cayman, we had a case where the IRS used investigators. That was certainly news to people who then got arrested and convicted. Is that something that's common? Is it
The use of undercover operations is something that civil does not do. That is something that is employed by the criminal division, so that's not something that civil does.
It's a tool that's used by our criminal investigation division. Now, regularity, I wouldn't say that it's used on every case, but where it seems to be appropriate, it might be used.
Any more questions?
What do you do after you receive information after a request? You find no connection with or U.S. income. Do you refer that information to another U.S. regulator or a foreign regulator?
We have exchanged information to foreign tax administrations based on information that we have obtained. As far as turning over information to other U.S. regulators, we're somewhat restricted by that same code section that restricts us under FOIA, the 6103, in terms of what we can disclose with other regulators. Generally, if we have a situation that we think there's criminal wrongdoing, we'll work with our criminal investigation division to see if there is a means or if there are criminal aspects involved that may be able to be exchanged that way.
With regard to foreign countries, though, there is a spontaneous exchange
Correct.
Opportunity where information comes in, and even though the other country hasn't asked for it or requested it, it would be turned over through the treaty spontaneous exchange requirement.
Right. If
I
we
mean,
had,
there are other avenues for disclosing.
that's right. If we had a taxpayer, say, that was not a U.S. citizen, we were looking into the substantial presence test to see if he was taxable in the U.S. and determined he was not, then we might pass that along to competent authority to see if they wanted to pursue it as a spontaneous exchange.
Competent authority is the term used for the people within tax authorities that have the authority to exchange the information. In other words, no IRS agents can't in and of themselves just disclose information. It has to go through the person designated as the competent authority for the organization. More questions?
Yes. Good morning. My name is Chris Redmond. I'm a bankruptcy trustee in Kansas City. I've been successful in getting Rule 6E orders in a number of criminal cases and getting the investigative files. With what, can we now get the MLAT information that's received also? Is that based on a country-by-country basis?
That's a little bit of a complicated answer. For those of you, he was referencing Rule 6E, which is the Federal Rules of Criminal Procedure that allow for a court to release information related to the grand jury. You know, there's always been a lot of a lot of discussion about what is a grand jury document and what is not a grand jury document. But any information obtained by the grand jury is the grand jury's. It's not the government's, it's not the courts, it's not the individual defendants, it's the grand jury. So you have to go through that process in order to apply to have that information released. Now, with respect to an MLAT, that's tricky. It depends on the specific country and what the use provision is with respect to how the data is turned back over to, let's say, the United States. So that's tricky. There have been circumstances in civil cases where, in U.S. tax court, for example, you know, our colleagues have gone through the process and asked, let's say, Austria or asked other countries, hey, we know that this data was turned over in connection with X criminal case pursuant to an MLAT. Would you give us permission and consent to use it in the civil case? So that has occurred, but that's something that's on a case-by-case basis, and it depends on the country.
Yeah, no, you were mentioned in your preparation, U.S. agencies. Through conversation with some of them, like DHS or DEA, what I learned is that especially in complex cases with human trafficking, you know, with drug trafficking, it's easier to go after the tax crimes and get the IRS engaged first to get the guys, and then go. I don't know if that's your experience.
I think generally, yes. You know, the elements of tax evasion are relatively simple. The second the funds go through the account, it shows dominion and control with respect to the account holder, who is the U.S. person, and if the money is declared or not. And of course, if there's the element of fraudulent intent there, it's much easier to go that route than it is. And I think, you know, we have something like a 90+% conviction rate with respect to tax cases. So that is probably the simpler way to go. You know, and I think as Brian had mentioned earlier, you know, we are looking and have been getting additional information from other law enforcement agencies, but it's sometimes not a two-way street. So a lot of times we can take the information, but we can't give it out unless there's a means to sort of to do that, whether it be through a grand jury process or if there's another criminal activity there that, you know, gives us a gateway in order to transfer the data.
I had one follow-up question. The Office of International Affairs in the past has allowed bankruptcy trustees in fraud cases to actually submit MLATs, which were submitted, and then the trustees got the information back. The last time I did it was about 5 years ago. Is that process still being approved and processed?
I know that the Office of International Affairs is with the Department of Justice, headquartered in Washington, and I know that they have a pretty robust office that's allowing for a lot of different types of things. In order to address your question specifically, I'm not sure as to that.
Okay, we're at the end of our allotted time. If there are other questions, I don't know, David, do you want to go long or do you want to terminate at this point?
No, we can take one more if somebody has.
Does anyone have a question they want to ask? And if not, we'll wrap this up. Okay, well, let me just tell you that it's an unusual thing for IRS to provide speakers of this level and caliber, and it's very unusual for them to be this candid and open with not just what they have done, but what they are going to be doing in the future. So I want to thank the IRS for letting them come and speak. I want to thank them for being so candid, and I hope you'll all join me in thanking them.